Welcome back, Mr. Norris Quakers, Senior Advocate of Nigeria, also joins us now to give his perspective on the Abia Court of Appeal judgment. Thank you for coming on this morning.
My pleasure.
Well, Chief Michael Sekome there says that he's sure that the Supreme Court will overturn these elections. You've also gone through the judgment. What do you think?
Well, I won't say that I'm sure. I can't say I'm certain. As a legal practitioner, I am only bound by the provisions of the law. Now, I've looked at the judgment. I've analyzed the pronouncement of the court. It is settled that any candidate who is challenging the result of an election, first and foremost, has a burden to establish what the result should have been. I remember one particular case, I think is Chukuma against Anyakora, where the court held that you must produce your original result. Now, in the case of ABGA, what I believe the candidate set out to establish was that he won the election and the person who was declared as winner did not obtain majority of the vote, because the word used in the Electoral Act, Section 138, is majority of the lawful vote cast. So you now need to establish that there were indeed unlawful votes. Now, if you're able to establish unlawful votes, what is the court expected to do? Under the Electoral Act, the court will cancel. Now, if the court cancelled, is the election such that can be sustained? Now, I've had some people refer to Section 140, sub 1 and 2, that where you cancel certain constituencies or result of some areas, what you're expected to do is to order for a rerun. Now, that section 140 sub 1 and 2 have been submitted to judicial interpretation, and the courts have annulled that particular section, a court in Lagos and also a court in Abuja, that you cannot dictate to the court what to do in such instance. Is election such that can be saved after the cancellation of the result from those local government as a result of overvoting? If the answer is yes, now, while one can dictate to the Supreme Court or sit back and conjecture what the outcome of the decision of the Supreme Court will be, but the provision of the Electoral Act is very clear. Any candidate who is challenging the outcome of an election, there are grounds, and one of the major grounds is that the candidate who was returned did not obtain majority of the lawful vote cast. And like I said, the word there is lawful vote cast. So the act is very clear.
Where does forensic come in here if they go before the court and we're talking about proof to show that there was actually unlawful votes among those other lawful votes? How does that help us?
It is not, this cannot be done at the Court of Appeal. It can only be done at the tribunal. The Court of Appeal is only saddled with records.
Now, coming from the tribunal.
Coming from the tribunal. Now, at the tribunal you have 3, at the Court of Appeal you have 5 justices. Now, the Court of Appeal will look at the records of what transpired at the lower court. Now, having been saddled with that responsibility, they've looked at it and discovered that if it was indeed established that there were overvoting in some areas and accordingly nullified, that what the tribunal should have done was to simply nullify. So since the tribunal refused or failed to do so, the Court of Appeal has the power to do so.
You know, but
and that's what they did.
Part of what the Court of Appeal also said was that it was wrong for the court to insist that the appellant failed to appear in person. His matter was not given due attention because he didn't appear in person. So does that then mean that they also considered the fact that he didn't appear and the cases that he raised, they then considered it and validated his election?
No, certainly, because you see, put it this way. If I'm challenging the election of a candidate, just like we do in civil cases, also in criminal cases, you must be in court, like it is said, he who asserts must prove. Why will you not show interest in your matter? Why? So it means you didn't give evidence. You didn't come to court to give the court your own side of the story. Technically speaking, it means the petitioner's case is unchallenged. Ordinarily, that's what it should be.
But in this case now, if you say that the Court of Appeal only considers records.
Yes.
And there were those who also said, look, the fact that the returning officer cancelled those 3 local government areas, which they say was, I mean, the heart of the whole elections, and then reverse himself because he didn't have powers to do so. Many already said that, look, isn't this some sort of script and pointed to the fact that someone somewhere wanted that cancelled, and so when they got to the Court of Appeal then upheld what the returning officer had done.
No, I would say so. Primarily, we've said it time and time again, the electoral officer or even INEC cannot cancel any election. The power to cancel is vested in the court. And I'll give you a particular instance. There's this case of article against INEC and Akinyemi, I've forgotten the other party, so a while back, where the Supreme Court held that the legislature and also the executive cannot usurp the power of the court under whatever guise. I mean, it's clear. So you can't exercise a function of the judiciary. The power to cancel any election or the result of any election is vested in the court, and that's what the court has done.
So if there's any case of overvoting, INEC cannot say, well, we don't trust the process that went on here.
No, INEC can't. It's for the court to determine. It's a candidate who is aggrieved.
So if nobody goes to challenge it, it will stand?
Well, somebody obviously will challenge it, but the way it works is if there is overvoting, what you're expected to do as a candidate is to go to the court or to the tribunal and establish that indeed, how do you establish overvoting? First, you look at the number of, and it's so common in this part of the world, number of registered voters against the votes. Now, if you had, say, 15,000, and then the result comes out, and the number of registered voters you know is 15,000, and then you have 20,000, how can that be? And that has always been the trend.
So INEC is bound by law to announce those results, even if
yes.
It's
so what INEC would do, because I remember the last chairman of INEC, Professor Jega, he said we can't do otherwise. It's for the parties to go to court and challenge it. They have to do what they have to do and make the ammunition available. And that's why I said, relying on that case I cited earlier, that once Chukwuba and Anyakura, that once you want to challenge the result of an election, you must produce the result. And when you produce the result, the electoral umpire is under a burden to establish that it followed the procedure recognized by law and that the outcome of the election is as a result of a properly conducted election. Mind you, like I said, there are different grounds under which you can challenge an election.
Now, what your colleague had said is that, you know, some of the things, some of the grounds upon which the appeal court reached its judgment were faulty. He talked about how, you know, the entire collation was looked at instead of polling unit by polling unit, you know, piecemeal collation, as it were. He also talked about testimonies of hearsay, which he also said was admissible in law, but sometimes can be faulted. What do you say about that?
I wouldn't want to join issues with my colleague, but let's just limit ourselves to what the law says. A candidate who takes his grievance to an election tribunal has a burden in law to establish his case in order to get the relief he's seeking. Mm-hmm. One of such is that the person who has been returned as duly elected is not duly elected, having not gathered or obtained majority of the lawful vote cast. The law is straight. He who asserts must prove. So the burden is on the candidate to establish that the candidate who was returned did not obtain majority of those lawful vote cast. And it's actually by evidence, documentary evidence. Now, that transpired at the tribunal. The tribunal, for some reason, overlooked some of those things. And a party who is aggrieved as a result of the outcome of a judgment constitutionally is empowered to go on appeal. So an appeal was lodged at the Court of Appeal. And so the Court of Appeal looked at the facts based on records transmitted to it and discovered that indeed, if it was established, right, based on the INEC staff who came to court and tendered documents, which the court evaluated, but did not pronounce on what it evaluated. And the matter went to Court of Appeal. The Court of Appeal can't take fresh evidence, except under special circumstances. The court is only bound by record. So looking at the record, you discover that if this was indeed established at the tribunal, what stopped the tribunal in cancelling the votes from this area as a result of overvoting?
So they cancelled, the protest now has been that they cancelled the elections, but then declared the petitioner as winner.
No, election was not cancelled. The votes from those local government areas were cancelled.
Yes.
Now, having cancelled, the question you then now ask yourself is this. Now, is it such that can save the election? Is it two-third majority? Is it two-third? The word used in the electoral act. Is it such that can save the election, unlike what transpired in Akwa Ibom, which the Court of Appeal reversed? That if it's such that can save the election will proceed. Now, some people, like I said, rely on Section 141 and 2. Section 141 and 2 is to the effect that if you establish certain irregularities in relation to the election, you do not declare the second runner-up, in quote, as the winner. The election is bought. The election is cancelled. That's 141 and 2. But if you look at 3, aside from the fact that 141 and 2 have been submitted to judicial interpretation, and the courts have nullified the provision as encroaching on the powers of the judiciary. Now, if you look at sub 3 of section 140, it now says that the court is vested that where a party established that the candidate who was returned did not obtain majority of the lawful vote cast, then that candidate who, that's in other words the petitioner, would then be declared the winner. And that's what happened here. That's exactly what happened.
So do you think, in your Sulaiman, in your opinion, do you think there are 3 local governments weren't important, especially when they're considered the stronghold of the defendant? Don't you think that they were important enough to have maybe a rerun declared there?
No, I don't think so. First and foremost was the allegation of overvoting established at the tribunal. If the answer is yes, what should the court do in that instance? Once the election is cancelled, once the votes are cancelled in those areas, and you have enough results, enough votes to establish, because first and foremost, you must have 2/3 votes cast in all those local government areas. 2/3. And so the question is, did the candidate of ABGA obtain 2/3 of the vote cast in those areas? If the answer is yes, the court was right to have declared him as the winner.
I'm looking at what this has thrown up a whole lot, because if you look at this now, you talk about substantial compliance, and you also look at some of those issues concerning those 3 local government areas, and they're trying to look at the number of votes cast, valid votes cast, and you put that side by side with what happened in Kogi, where the elections, don't forget that in this particular case, it was postponed after the man had made a mistake by annulling those, cancelling those elections for those 3 local government areas. They went on to do a rerun in those areas and still were here. And you put that side by side with what has happened in Kogi State, and you also look at even a couple of other places. How does this make sense when you also know on that day some other elections held, for instance, into houses of assembly for this state? In this case, we'll restrict ourselves to Abia State. If we are saying that these have been cancelled and the elections for others have been upheld, for instance, the House of Assembly, how does that make sense, if there's any logic there, that you're cancelling what is coming for the governorship elections, which is the contention now, and those that have gone on the same day for the assembly and not on the focus?
Good. 2 things will have happened. Let's put it this way. In relation to the